Connecting inspections to disclosure responsibilities in HUD transactions. In the last section, we discussed inspections, repair escrows, and how buyers investigate HUD homes before closing. Now we move into one of the most important legal and ethical responsibilities in real estate: disclosure. Some agents mistakenly assume HUD owns the property, so disclosure rules do not really apply. That is not true. Even though HUD homes are sold as is, agents still have legal and ethical duties to disclose known material facts. In Arizona, disclosure responsibilities are taken seriously. This section connects directly to property classifications, PCR reports, inspections, financing limitations, buyer expectations, and known defects. Once defects or hazards become known, disclosure obligations begin. HUD's disclosure obligations. HUD acquires homes after FHA-insured foreclosures and resells them through HUD Home Store. Unlike traditional Arizona sellers, HUD usually does not occupy the property and does not complete a traditional seller property disclosure statement, commonly called the SPDS. Instead, HUD may provide property condition reports, lead-based paint addenda, utility information, environmental disclosures, available repair observations. HUD's goal is not to guarantee condition. The goal is to provide available information so buyers can make informed decisions. What HUD may disclose. HUD disclosures may include information about roof leaks, plumbing issues, HVAC problems, structural concerns, mold concerns, environmental hazards, electrical deficiencies, lead-based paint concerns, safety hazards. Because HUD homes are sold as is, buyers must understand that disclosure does not mean HUD will repair the issue. It means the buyer has information to evaluate the property. Understanding material facts. A material fact is information that could affect the property's value, the buyer's decision-making, the buyer's use or enjoyment of the property. Examples may include foundation cracks, major water damage, mold contamination, roof failure, structural movement, environmental hazards, or significant plumbing defects. Agents cannot ignore or conceal material facts simply because the property is sold as is. A real-world disclosure problem. An Arizona agent showed a HUD property with visible water stains on the ceiling. The PCR mentioned prior water intrusion concerns. During showings, the agent casually said, "It is probably just old staining." Later, the buyer discovered roof leaks and mold issues after closing. The buyer claimed the agent minimized the condition instead of recommending further investigation. The lesson is simple: never downplay known or visible issues. A safer response is, "I recommend further evaluation by a licensed professional." The Property Condition Report. The Property Condition Report, or PCR, is one of the main disclosure tools in HUD transactions. It is generally prepared by HUD's field service manager and includes limited visual observations about the property. The PCR may reference electrical systems, HVAC systems, plumbing systems, roofing observations, foundation observations, appliances, safety concerns. However, the PCR is not a warranty, guarantee, full inspection, or exhaustive report. It is only a limited visual assessment. Why buyers should not rely only on the PCR. A buyer once reviewed a PCR on a HUD home in Gilbert and thought the property looked problem-free. The buyer almost skipped inspections. Fortunately, the agent encouraged a professional inspection. The inspection uncovered hidden plumbing leaks, improper electrical repairs, roof deterioration, and HVAC failure. The PCR should always be viewed as a starting point, not the final answer. The agent's role in disclosure. Arizona agents have serious disclosure duties. Under ARS Section 32-2156, licensees must disclose known material facts affecting the value or desirability of the property. Under AACR 4-28-1101, A, agents must deal fairly with all parties. Under AACR 4-28-1101, B, agents must disclose material information known to them. These duties apply even when HUD owns the property. The property is sold as is. The buyer waives certain contingencies. An agent cannot stay silent about known material issues. What agents should never do. Agents should never conceal known defects, minimize visible damage, guess about repairs, misrepresent property condition, discourage inspections, claim a defect is minor without expertise. Statements like, "That crack is nothing," or "HUD would have fixed it if it mattered," can create serious problems. Agents should recommend qualified professionals when issues are outside their expertise. Environmental hazards and older HUD homes. Older HUD homes may involve environmental concerns such as lead-based paint, mold, asbestos, water intrusion, underground storage tanks, soil contamination. For homes built before 1978, federal law requires lead-based paint disclosures. Buyers must generally receive available lead information, lead hazard disclosures, educational materials, and an opportunity to investigate. Lead exposure can create serious health concerns, especially for children and pregnant women. Documentation protects everyone. One of the best habits agents can develop is documenting important communications. Good documentation may include disclosure acknowledgments, inspection recommendations, PCR delivery confirmations, email communications, repair discussions, buyer acknowledgments. If a dispute arises later, documentation becomes extremely important. Experienced agents understand. If it is not documented, it becomes difficult to prove. Best practices for HUD disclosure management. Professional HUD agents should deliver available documents promptly, encourage inspections early, recommend qualified inspectors, avoid speculation about repairs, put important communications in writing, document buyer decisions carefully. These habits protect the buyer, brokerage, transaction, and agent's license. Disclosure does not mean the deal dies. Some agents fear disclosure will kill the transaction. In reality, informed buyers often still move forward when pricing reflects condition, repair costs are manageable, and expectations are realistic. The goal is not to scare buyers. The goal is informed decision-making. Professional disclosure creates stronger transactions and better client trust. Arizona Commissioner Standards and Disclosure Compliance. Arizona Commissioner Standards reinforce honesty and reasonable care. Agents must communicate material facts accurately, avoid concealment, recommend inspections appropriately, treat all parties fairly, maintain professional transparency. Failure to disclose known issues may create lawsuits, license complaints, disciplinary action, and reputation damage. The best protection is professionalism, honesty, documentation, and education. As we continue through this course, we will build from disclosure obligations into HUD transaction management, contract compliance, timelines, and real-world problem-solving situations agents may encounter during the closing process. Online discussion. Question 1. Why is the property condition report not considered a full home inspection? Answer. The PCR is only a limited visual assessment and may not identify all hidden defects or future repair concerns. Buyers should still obtain professional inspections. Question 2. What is considered a material fact in a HUD transaction? Answer. A material fact is information that could affect the property's value, the buyer's decision-making, or the buyer's use and enjoyment of the property. Question 3. Why should agents avoid minimizing visible defects or repair concerns? Answer. Minimizing defects could mislead buyers and create legal or licensing liability if serious issues are later discovered. Agents should recommend professional evaluation instead.